Excuse me, Your Honor. They're all lies. Utter lies.
And they've not been responded to.
Shut up.
Good morning. Can everyone hear us okay?
Yes.
I can hear you okay.
For the record, this matter is before the court at the request of the plaintiff, Patrick Henderson, and his attorney, Matthew Viddo, to place the terms of a proposed agreement on the record. This hearing is being conducted via Zoom. Present is attorney Matthew Viddo, representing the plaintiff, Patrick Henderson. Mr. Henderson appears to be present. Also, the defendant, Diana Henderson, appears to be present. Good morning, everyone.
Good morning.
Court notes that this matter is scheduled for trial on April 25. If in fact the parties have an agreement today, then that trial day will be vacated. Do you understand, Ms. Henderson?
Yes.
Yes. Okay. All right, Mr. Viddo. If the court recalls, the primary issue was personal property division, some automobiles, correct?
Yes, Your Honor. I think this judgment, it resolves everything presently before the court.
Okay. Has Ms. Henderson actually approved a judgment?
She has. I have an e-signed copy. I believe a copy may have been dropped by your office. If not, then I can make sure you have a copy of it today. But both parties e-signed it. I have the signature log, and we're ready to go.
Okay. The court has not seen the judgment. I don't know if it's in the clerk's office. Do you know, was that delivered directly to the court, or was it delivered to the clerk?
It should have been delivered to your chambers, Your Honor.
Okay.
If it was not, then I apologize. I'll make sure that a copy is taken to the court today. I can put the material terms on the record.
Please. Yes, the court's not received that. So yes, if you could find where that's situated, you deliver that to the court so the court can enter that today. But Mr. Viddo, please be placed on the record what you understand to be the parties of full agreement.
Absolutely, Your Honor. So the judgment of divorce has the standard terms regarding the breakdown of the marital relationship and the object of matrimony being destroyed. The parties have no minor children together. It's a short-term marriage. In this judgment, neither party is being awarded spousal support, and they're waiving all future spousal support in accordance with Staple v. Staple. Has a standard statutory insurance provision notifying the parties that they have to change their beneficiaries on their own. Has a clause in there saying that each party can obtain COBRA insurance coverage if available and at their own expense. Says that each party is going to keep their own pension or 401k retirement plan free and clear of any interest of the other. Neither party owns or has any interest in any real estate, so there's a clause in there just noting that. It also says the parties are awarded the personal property in his or her possession, as well as their own individual bank or financial accounts and any funds therein. And they're going to assume and pay any debt owing on any personal property retained by him or her. Plaintiff is specifically awarded all disability payments and other benefits through the Veterans Administration, whether connected to his military service or otherwise. He's receiving a 2006 Ford Aerostar that's red in color. Defendant is being awarded all her personal belongings, any tools of her trade, furniture, appliances, and the like. A 2000 GMC pickup that's reddish brown in color. A 2014 Cadillac SRX4 that's dark gray in color. And obviously, as I said before, both are receiving their own bank accounts and financial accounts. Marital debts, they have no joint debt. So it's my understanding that Ms. Henderson has some student loans she's keeping and assuming those. They're going to file their 2023 taxes, married filing separately, and they're going to keep whatever refund or liability that they have on their own filing. Ms. Henderson's former name is being restored to her of Davies. The party's going to pay his or her own attorney's fees. And it has, they're each waiving any discovery, trial, and whatnot. And that's the complete judgment, Your Honor.
Thank you. Mr. Vito, thank you. With respect to the two automobiles, we have a GM pickup and a Cadillac. Who was awarded which vehicle?
So there's three vehicles. There's a Ford Aerostar, there is a pickup, and there is a Cadillac. And the pickup and the Cadillac are being awarded to Miss Henderson, and the Aerostar is being awarded to my client.
And there's no indebtedness on those vehicles, is that correct?
I believe that there is none regarding any of the vehicles. They're all owned free and clear.
Thank you, Mr. Vito. Ms. Henderson, did
Yes.
Mr. Vito accurately state your agreement?
Yes, Your Honor.
Right, Ms. Henderson, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yeah.
Thank you. Mr. Vito, we did take the proofs back on February 29th, 2024, but the court will simply update those for Ms. Henderson. She's not currently pregnant, but if you want to warn Mr. Henderson regarding the terms of this agreement, please.
Yes, Your Honor. Thank you. Mr. Henderson, you've heard the terms of the agreement that were placed on the record?
Yes, I have.
That's your agreement, right?
Correct.
No one has pressured you or, threatened you or anything to get you to enter into this agreement?
No, sir.
Do you believe that it's a fair agreement?
Yes, sir.
I know that there was other proposed judgments that we had provided to Ms. Henderson. And this is ultimately the terms that are in this judgment are the ones that you wanted me to put in there. Is that right?
Correct.
All right. And part of that addition of other information or other, I guess, bargains into this judgment was because you didn't want to go to trial on this matter, right?
Yeah. I've had over.
And you understand that when this judgment is entered by the court, any right to a trial is waived, right?
Yes.
Okay, and we did participate in discovery in this. We did send discovery requests to Ms. Henderson, right?
Yes.
Okay, and she did not answer that discovery, but when this judgment is signed by the court, all discovery is waived too, right?
Right.
Part of this agreement involves the waiver of spousal support. You understand that applies to both you and her.
Yes.
So, and this, once this judgment is signed, neither you nor her can come back to the court at a later time and ask the court to grant any kind of spousal support.
That's correct.
It's forever barred.
Yes.
Okay. Now on this, you signed it electronically, right?
Yes, sir.
And you also initialed each page of the judgment, correct?
Yes, sir.
Okay, and you want the court to grant this judgment?
Yes, sir.
I have no further questions, Your Honor.
Thank you, Mr. Vito. Ms. Henderson, can you please state your name and current mailing address for the record?
Diana Henderson, Michigan 48043.
Thank you. Ms. Henderson, did you hear the testimony of your husband, Patrick, this morning?
Yes, I did.
Is this testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Is it true that you have approved with the e-signature the proposed judgment of divorce prepared by Mr. Vito?
Yes, Your Honor.
And you're asking the court to enter that judgment today, is that correct?
Correct.
Do you understand that there will be no trial, that the trial scheduled for April 25 will be canceled and vacated?
Yes.
Do you have any questions for the court?
No.
Do you have any questions for Mr. Vito?
Yes, one. Mr. Vito, we discussed about having the record sealed, and you were going to bring that up.
Yes, Your Honor. Ms. Henderson had asked, there are certain items
Lies.
in
Lies.
the request to admit that she finds potentially embarrassing, and she did not respond to that. And she wanted me to ask the court whether or not the court would seal the request to admit. I told her that it's entirely up to you, but that I would make that request.
I'm sorry. You filed a request for admissions back in January, is that correct?
Yes, Your Honor.
And you're asking that those requests be removed from the court file and sealed by the clerk?
That's what Ms. Henderson is asking.
Excuse me, Your Honor. They're all lies. Utter lies. Mr. Henderson has done nothing but play games with courts, getting PPOs that aren't even warranted. He makes up lies about this, and all these lies are out there about me now. And I would like to where people can't read these about me because he wants to put these lies out there.
But this is not an electronic file. Someone's got to actually come into the courthouse physically to look at it, and there's no admissions. There's just an allegation, Ms. Henderson. The court sees no reason to seal this, and there's no legal basis.
Okay, that is fine if they're just allegations and they're not. I mean, because he puts them out there and they're all lies. And I'm just sick of it. I'm sorry, Your Honor. I'm just glad I'm getting rid of this narcissist.
Okay, it's noted for the record, your position that they're all lies, Ms. Henderson, but the court doesn't see any basis to seal these pleadings in this file.
No.
They've not been responded to.
Shut up. Shut up. Shut up. Sorry, Your Honor. No, nothing, Your Honor. I was not speaking to you. I'm sorry.
She's being.
I was talking. I was
Mr.
talking
Henderson,
to the
please
dog.
be quiet.
Let's mute. Let's mute Ms.
Excuse me.
Henderson.
I
Ms.
was
Henderson, can
talking
you
to the
please?
dog that
Ms. Henderson, please, both of you stop.
Shut
Both
up.
of you stop. You're
I
adults.
was just
Come on.
okay, Your Honor. I was just talking to the dog that keeps barking. I'm sorry.
Okay. Do you both want to get divorced today?
Yes, I do, definitely.
Okay.
Right.
One last question, Ms. Henderson. Last time you were in court, you were on pain medications. You were in a neck brace today.
Yes.
Are you under the influence of any medication that could impair your judgment to make a decision?
Not now, Your Honor.
All right.
I'm off them.
Mr. Vindo, do you have any questions of Ms. Henderson?
Just one, Your Honor. Ms. Henderson, have you disclosed all your assets to me during this proceeding?
All I have is Social Security. So
Okay, but you've hidden nothing?
no, nothing.
I have no further questions, Your Honor.
All right, thank you, Mr. Vindo. The court would like to thank and acknowledge Mr. Vindo for his assistance on helping facilitate a resolution. Mr. Henderson, without question, the best resolution is one which the two of you reach and settle rather than have thrown things up in the air and have the court decide these matters. Maybe the value of a motor vehicle is not great enough to incur the aggravation of a trial.
Absolutely, Your Honor.
So you made the right decision. You were well guided by Mr. Vidido. I know that it's been frustrating because we have pleadings that were now answered by Ms. Henderson, but she's representing herself, and it makes it more difficult. So the court appreciates your efforts, Mr. Vidido. If you get the judgment to the court today, we sign that. Ms. Henderson, when you get the judgment, you want to take a copy to the Secretary of State and Social Security to facilitate the legal change for the last name. So don't forget to do that, okay?
Okay.
Again, with this agreement of the record, the court will cancel and vacate the trial scheduled for April 25 at 8:30. Based upon the testimony that's been presented today, as well as previously, the court finds that jurisdiction has been established and that there has been a breakdown in the marriage relationship to the extent that the object of matrimony has been destroyed and there's no reasonable chance of reconciliation. According upon receive that judgment later today, the court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved. Judgment shall enter granting a divorce from bonds of matrimony. That will conclude this hearing. You can both zoom out. Thank you again, Mr. Biddle. We look forward to receiving that judgment sometime today.